So imagine trying to run a modern, a 2023 smartphone on an operating system that was built back in 1988.
Right. Yeah, that would be a total disaster.
Exactly. I mean, you pull it out of the box, try to load up a high-definition video or like a social media app, and the entire device just instantly crashes.
Oh, absolutely. The hardware might be shiny and new, but the internal logic just, well, it cannot comprehend the demands of the modern world.
Yeah, and yet, until very recently, that is exactly what one of the world's major justice systems was doing with its legal professionals.
It's wild, right? Operating a 21st century legal framework using this 20th century ethical compass. We're looking today at a 2023 Supreme Court resolution from the Philippines. It's formally designated as AM Duanon 220901SC.
Right.
And this document adopted the new Code of Professional Responsibility and Accountability. People commonly refer to it as the CPRA. And it entirely replaced a code of ethics that had been governing lawyers since 1988.
Okay, let's unpack this because 1988 was a world without the public internet.
Hmm.
No smartphones, no social media algorithms driving public opinion. I mean, for decades, lawyers were operating under rules designed for, like, typewriters and physical law libraries.
Exactly.
So our mission for you today in this deep dive is to explore how this new CPRA completely rebuilds the architecture of legal and judicial ethics from the ground up.
Yeah, it's a massive overhaul.
We're going to look at how a huge justice system tackles modern disinformation, the backroom influence, the government revolving door, and, the mechanisms holding lawyers accountable.
And most importantly, we'll uncover how the conduct of everyday lawyers directly safeguards or jeopardizes the integrity of the judges they appear before.
Right.
Because to appreciate the mechanics of these new rules, we first have to look at the foundational shift in how the Supreme Court actually views the lawyer.
Oh, the preamble stuff, right.
Yeah, the old perception of a lawyer was often this detached, clinical, almost robotic advocate whose only goal was to win at all costs. But the CPRA shatters that illusion immediately in its preamble.
It does, yeah. The text actually describes the Filipino lawyer as an amalgamation of influences.
Which is such an interesting phrase.
It is. It specifically lists out familial, cultural, religious, academic, political, and philosophical backgrounds.
What's fascinating here is that the Supreme Court is pulling back the curtain, right? They're acknowledging human nature.
Right.
A lawyer is a social being who inevitably develops preferences and biases. The code doesn't ask lawyers to pretend those biases don't exist. It brings them right into the light.
Yeah, it's very realistic.
The text explicitly states that the CPRA exists to regulate those personal choices, ensuring they don't override the institutional objectives of justice.
Well, wait, I have to push back on that a bit.
Sure.
If the highest court is openly admitting in a formal document that lawyers have these deep-rooted personal, political, and religious biases, doesn't that sort of destroy the whole illusion of blind justice?
That's a great point.
Like, how do you mandate that an inherently biased human being act as an objective officer of the court without, completely erasing their humanity?
Right. Well, they do it by redefining what objectivity actually looks like in practice.
Mm-hmm.
The code bridges the gap between human bias and institutional justice through a highly engineered definition of one word, and that word is integrity.
Integrity?
Yeah, and the CPRA integrity isn't just a vague, feel-good moral concept.
Right, not just a buzzword.
Exactly. It's an active mechanism. It's defined as the sum total of 6 specific pillars: independence, propriety, fidelity, competence, equality, and accountability.
Okay.
So a lawyer's personal, political, or religious biases are allowed to exist in their private mind. But the moment they step into their professional role, the code demands those biases be completely subordinated to those 6 pillars.
I see. So if you're listening to this and you find yourself needing to hire an attorney, you're not getting an emotionless droid.
Right. No droid.
You're getting a human being with their own worldview, but they are bound by an operating system integrity that forces them to put the fair administration of justice above their personal prejudices.
Perfectly said. And that transition from internal mindset to external behavior brings us to the most radical upgrade in the code.
Right, because if we understand that lawyers are deeply connected to their social surroundings, we have to look at how the CPRA governs the loudest, most volatile social environment ever created.
Oh, yeah. The internet.
The internet. This is where the gap between 1988 and 2023 is just staggering. Under Canon II, which covers propriety, there is a comprehensive new section dedicated to the responsible use of social media.
It's about time, honestly.
Seriously. Lawyers are now explicitly banned from knowingly posting, sharing, or disseminating false or unverified statements. I mean, they are legally barred from participating in disinformation campaigns.
And the code goes further by stripping away anonymity.
Oh yeah, the fake accounts rule.
Yes. Lawyers are strictly prohibited from creating or maintaining fake accounts or avatars to hide their identity for the purpose of circumventing the law or their ethical duties.
Here's where it gets really interesting, though. Think about how you or anyone else uses social media. It is incredibly common for people to fire off quick opinions or ask for advice in the comments section.
Oh, all the time.
Right. Let's say you tweet at a lawyer asking a specific question about your messy divorce or a contract dispute. Under Section 43, if that lawyer gives you legal advice based on those specific facts you disclosed online, they instantly trigger a limited legal service relationship.
Wow.
Yeah.
Which fundamentally changes the dynamic.
Completely.
The moment that lawyer replies with specific advice, even if it's just in a direct message or a public comment thread, they are suddenly bound by the heavy ethical duties of the CPRA.
Right.
They're bound by confidentiality. They're bound by conflict of interest rules. I mean, they can't turn around the next day and represent your spouse in court, claiming, oh, it's just a casual tweet.
Exactly.
The CPRA treats that digital interaction as a real, binding professional obligation.
It is a massive trap for lawyers who are just trying to build their online brand by handing out free advice.
Oh, definitely.
But the social media rules aren't just about protecting clients. They are heavily focused on protecting the judges. And this ties into Section 19, the sub judice rule.
Right, the sub judice rule. So sub judice refers to matters that are currently under judicial consideration.
Right.
The rule forbids lawyers from using any forum or medium, especially social media, to comment on or publicize opinions pertaining to a pending proceeding.
Because they can't create a widespread perception of guilt or innocence before the judge makes a final decision.
Exactly. And they cannot impute improper motives to the members of the court.
Let's actually look at the mechanics of why this is so critical for judicial ethics. I like to think of a judge's decision-making process as a highly sterile operating room.
Okay, I like that analogy.
Right. The only things allowed in that room are the verified facts, the sworn testimonies, and the applicable laws. Those are the sterilized instruments of justice.
Yeah.
Social media outrage, viral hashtags, and public opinion polls. They're like someone pumping unfiltered, contaminated air straight through the ventilation system.
That is a perfect way to visualize it. Because judicial ethics rely on impartial tribunals. A judge must decide a case based solely on the evidence presented on the record.
Right.
If a lawyer goes on a podcast or takes to Facebook to rant about how obviously guilty a defendant is or how biased the judge is, they are actively trying to win the case in the court of public opinion.
Yeah.
They are deliberately pumping contaminants into that sterile operating room. Even if the judge ignores the public noise, the public's trust in the final verdict is completely compromised.
Yeah, the trust is gone.
Right, so the CPRA shuts down that tactic to preserve the integrity of the tribunal.
Well, if social media rules restrict how lawyers try to influence a judge publicly, we have to look at what stops them from leveraging their personal relationships to influence a judge privately.
Oh, right, the backroom stuff.
Yeah, we're moving from external public pressure to backroom influence, which brings us to canon the third, and that's fidelity.
Fidelity involves advancing a client's cause with devotion, but doing so while fiercely protecting the administration of justice. And a significant vulnerability in any justice system is the so-called revolving door between government service and private practice.
This is a huge deal. Section 29 specifically targets this. It dictates that justices, judges, clerks of court, and prosecutors who leave government service are banned from appearing before any court within their former territorial jurisdiction for a full year.
A mandatory one-year cooling-off period.
Exactly. Just think about the psychological impact of that on the public.
It's massive.
Imagine you are a regular citizen walking into court for a lawsuit. You look across the aisle and see that the opposing lawyer is the former judge of this very courtroom.
That would be so intimidating.
Right. They retired last week, and today they're chatting up the current judge and the clerks like old drinking buddies. You would immediately feel like the game was rigged against you.
Absolutely.
It's like a referee taking off their striped shirt in the middle of a game, throwing on a team jersey, and instantly running onto the field. The public needs that cooling off period to believe the referee wasn't secretly calling plays for that team all along.
Yet, if we connect this to the bigger picture, this cooling off period prevents the monetization of inside influence.
Yes.
Judicial ethics demand that every party stands on completely equal footing.
Yeah.
Actual bias is dangerous, but the appearance of bias is equally destructive to the system's credibility.
And the CPRA also creates an absolute fortress around judges when it comes to financial influence.
Oh, the gift-giving rules.
Yes, Section 21 establishes a strict prohibition against gift giving. Lawyers cannot directly or indirectly give gifts, donations, or contributions of any value to any court, tribunal, or government agency.
Not even small things.
Nope, not for birthdays, not for holidays. You can't even send a generic fruit basket to the clerk's office.
Wow. But the mechanism here makes sense. It's about preventing the slow, insidious erosion of impartiality.
Right.
A small gift today might just seem polite, but it establishes a dynamic of reciprocity. The CPRA just eliminates the gray area entirely. It keeps the relationship strictly clinical and professional. Furthermore, the code illustrates how deeply lawyer accountability is intertwined with judicial discipline. For instance, if a lawyer files a complaint against an incumbent justice of the Court of Appeals or lower court judges, it isn't handled by a standard disciplinary board.
Okay, who handles it then?
Well, under Rule 140, the Integrated Bar of the Philippines forwards those complaints directly to the Supreme Court.
Wow, straight to the top.
Yeah, disciplining the judiciary requires the absolute highest level of scrutiny.
So we've explored how the code builds walls to protect the courts from lawyers, whether it's, social media pressure or backroom influence. But a justice system doesn't exist just to protect its judges.
Right, it exists to serve the public.
Exactly. So how does this document protect everyday citizens, especially the marginalized, from the immense power of the legal system?
That philosophy is embedded in Canon V, which focuses on equality. And the CPRA moves far beyond standard non-discrimination clauses. I mean, yes, Section 1 states a lawyer cannot decline representation based on nationality, sexual orientation, gender identity, religion, disability, or socioeconomic status.
The usual protections.
Right. But the real teeth of this canon are found in Section 2, which deals with vulnerable persons.
The code provides a highly specific definition of vulnerability, actually.
It does.
It includes children, the elderly, the homeless, persons with disabilities, persons deprived of liberty, victims of domestic violence, and ethnic minorities.
The crucial mechanism here is that the code mandates lawyers to observe a higher standard of service suited to the particular needs of these individuals.
A higher standard.
Yes. It shifts the burden. It's no longer enough for a lawyer to simply say, well, I won't discriminate against you. The lawyer must actively assert that person's right to meaningful access to justice. If a client has a severe disability or faces a massive language barrier, the lawyer is ethically required to expend extra effort to ensure the client actually understands and participates in their own defense.
But practically speaking, this sounds like an enormous burden on lawyers. Let's look at Section 3, which says a lawyer cannot refuse to represent an indigent person.
Right. Someone who lacks sufficient money for basic food and shelter.
Yeah. What if a lawyer is already drowning in cases? Or what if they just hate the client? Does this code literally force a private citizen to work for free to the point of their own ruin?
Well, the Supreme Court is practical, so the text provides very specific, narrow escape hatches.
Okay, good.
A lawyer can refuse an indigent client if they genuinely lack the competence to handle the specific legal issue, or if their current caseload is so overwhelming that taking the case would actually prejudice the client due to neglect.
Got it. And there's also a conflict of interest exception. The text says you can refuse if you are closely related to the adverse party or their counsel. It uses the terms 6th degree of consanguinity or affinity for the party and 4th degree for the counsel.
Right. And just to translate that out of legal jargon, consanguinity means blood relations, and affinity means relations by marriage.
Okay.
So the code is essentially saying, unless the person suing your indigent client is literally your cousin or someone closer in your family tree, you cannot use family ties as an excuse to dodge the case.
Wow, they really locked that down.
They did. Barring those very specific logistical roadblocks, providing legal service to the poor is not framed as charity in the CPRA. It's a strict, enforceable duty.
So what does this all mean? We have these incredible pillars: independence, propriety, fidelity, competence, equality. They sound fantastic on paper.
Yeah, they do.
But an operating system is completely useless if it doesn't have a way to handle malware. What are the actual consequences when a lawyer violates these rules?
A code of ethics without enforcement is just a list of suggestions. Canon the Sixth deals with accountability. Disciplinary proceedings under the CPRA are confidential in character, but summary in nature,
Summary in nature meaning.
meaning they are engineered to move swiftly without the endless delays you might see in a regular civil trial. The Integrated Bar of the Philippines provides a roster of 150 investigating commissioners who handle the heavy lifting of these investigations.
And the offenses are categorized into light, less serious, and serious, right?
Yes.
The serious offenses under Section 33 are really intense. We're talking about gross misconduct, bribery, misappropriating client funds, and serious dishonesty.
It also notably includes gender-based sexual harassment, sexual abuse, and gross ignorance of the law when combined with bad faith.
Yeah.
If a commissioner finds a lawyer guilty of a serious offense, the system just drops the hammer. Sanctions include fines well over 100,000 pesos, lengthy suspensions, or outright disbarment.
Permanently stripping them of their license to practice law. And if they just get suspended, it isn't like a sports penalty box where you just sit out for a few months and skate back onto the ice.
No, not at all. Section 45 details a fascinating procedural hurdle for suspended lawyers.
Oh, I was reading this part.
Yeah, once the suspension period expires, they can't automatically resume practice. They must file a sworn statement with the Supreme Court.
Under oath.
Right. They have to prove, under oath, that during their suspension, they didn't secretly file pleadings, they didn't give legal advice, and they properly informed all their clients of their status.
It's the ultimate paradox of the entire code, really.
How so?
Well, the very document you have to submit to prove you are ethical enough to return to the profession will instantly destroy your career if you lie on it.
Oh, absolutely.
If the court finds out a lawyer made a false statement on that sworn document, it becomes the direct basis for a brand new disbarment complaint. It's basically a final purity test before they let you back in the door.
This raises an important question regarding how the system balances punishing actual corruption against protecting its lawyers from harassment, though.
That's true.
In these administrative cases, Section 32 establishes that the burden of proof falls entirely on the person filing the complaint. They must prove their allegations with substantial evidence.
Substantial evidence, which is defined as the amount of relevant evidence a reasonable mind might accept as adequate to justify a conclusion.
Right.
It's a lower bar than beyond a reasonable doubt used in criminal trials, but it still requires solid, tangible proof. You can't just file a complaint to harass opposing counsel because they beat you in court.
Exactly. In fact, filing a frivolous or malicious complaint is itself a disciplinary offense that will get you investigated.
Wow.
The mechanism is carefully calibrated. It ensures the disciplinary board isn't weaponized by disgruntled litigants while still maintaining a realistic threshold to catch and punish genuine misconduct.
Right. So as we step back and look at the entirety of this deep dive, it's clear that the 2023 Code of Professional Responsibility and Accountability is so much more than a manual of do's and don'ts.
It really is.
It's a comprehensive philosophy for a modern era. It forces the legal profession to adapt to digital reality by aggressively regulating social media and disinformation.
Yeah.
It builds walls around judges, protecting judicial independence by stopping the revolving door and silencing trial by public opinion. It demands active protection for the most vulnerable citizens, and it backs up every single ideal with severe career-ending accountability.
It demands a profound psychological and ethical commitment from anyone who takes on the title of attorney. And perhaps the most revealing part of this entire resolution is actually hidden at the very end.
Oh, right.
The document concludes with a revised lawyer's oath. Every single lawyer must swear this oath to practice law.
And this revised version fundamentally shifts the goalposts. It requires lawyers to explicitly swear that they will promote the rule of law and to quote the text, directly work towards a regime of truth, justice, freedom, love, equality, and peace.
The inclusion of the word love is just stunning in this context.
It really is.
It suggests an underlying philosophy that a justice system is not merely a mechanism for resolving disputes or distributing punishment. It implies a duty toward restoring the community.
Love. I mean, think about how radical that is for a Supreme Court resolution.
Yeah.
If you have ever been involved in a lawsuit or even just watched a legal drama, we often perceive the law as a cold, adversarial, and deeply clinical machine. It's all about penal fines, financial damages, and outmaneuvering the other side.
Always.
But when a nation's highest court legally mandates its attorneys to swear an oath to promote a regime of love, it forces a massive paradigm shift. It makes you ask, does that fundamentally change the very nature of what a justice system is meant to achieve?
It demands that lawyers look beyond the tactical victory of a single case. and consider the holistic impact of their actions on society.
It's the ultimate upgrade. If a legal professional is still trying to run that 1988 operating system, where everything is purely combative, anonymous, and completely disconnected from the human element, their career is going to crash.
Fast.
The 2023 upgrade requires uncompromising integrity, radical accountability, and surprisingly, a legally binding commitment to a regime of love. That is something powerful to mull over the next time you step into a courtroom, or honestly, even the next time you log onto social media to post about a trending news story. Thank you for joining us, and we will catch you on the next deep dive.